right, guys, so here's part two of that first one. Here, the Supreme Court of the state of Washington has defined the word traffic in either its primary or secondary sense in reference to business and not to mere travel. So it is clear that the term traffic is business related and therefore it is a privilege. The net result being that traffic is brought under the police power of the legislator. The term has no application to one who is not using the road as a place of business. Sure doesn't. License. So this is for any of those haters, traitors, and trolls who have any doubts as to what license is. Here's what the Supreme Court says a license is. It seems only proper to define the word license, as the definition of this word will be extremely important in understanding the statutes as they are properly applied. Permission by competent authority to do an act which without permission would be illegal, a trespass, or a tort. People versus Henderson, 218 Northwest 2D. Leave to do a thing which licensor could prevent. Western Electric Company versus Payson, Reproducer Court, 42F 2D. In order for these two definitions to apply in this case, the state would have to take up the position that the exercise of a constitutional right to use the public roads in the ordinary course of life and business is illegal, a trespass, or a tort, which the state could then regulate or prevent. This position, however, would raise magnanimous constitutional questions, as this position would be diametrically opposed to fundamental constitutional law. See conversion of a right to a crime, infra. In the instant case, let's see where we at. I lost my spot, guys. Okay. This position, however, would raise magnanimous constitutional questions, as this position would be diametrically opposed to fundamental constitutional law. See conversion of a right to a crime, infra. In the instant case, the proper definition of a license is a permit granted by an appropriate government body, generally for consideration to a person, firm, or corporation, to pursue some occupation or to carry on some business which is subject to regulation under the police power. Rosenblatt versus California State Board of Pharmacy, 158 P2D 199203. Now, did you guys hear that case? Okay, did you hear that case? Rosenblatt versus California State Board of Pharmacy. Okay, obviously they're talking about a pharmaceutical license. However, the point of the use of that case is license in general. And that's what a lot of your haters, traitors, and trolls do not understand, is you can take related issues from other cases, such as this pharmacy case, and use the license that they are referring to, because all licenses are the same. They're a requirement to do something. So the rules for one license applies to all license. They say, well, no, not really. Yeah, really, it does. It's a license to do something. So therefore that rule applies to all license. This definition would fall more in line with the privilege of carrying on business on the streets. Most people tend to think that licensing is imposed by the state for the purpose of raising revenue, yet there may well be more subtle reasons contemplated, for when one seeks permission from someone to do something, he invokes the jurisdiction of the licensor, which in this case is the state. In essence, the licensee may well be seeking to be regulated by the licensor. A license fee is a charge made primarily for regulation, with the fee to cover costs and expenses of supervision or regulation. State versus Jackson 60, Wisconsin 2D 700 211, Northwest 2D 480 487. And did you hear that? I made a video on that, guys. I told you guys, you get a license, you put yourself in their jurisdiction. If the DMV does not have jurisdiction over you, they can't do nothing to you. The rules don't apply, because a license is a contract. You have to remember that. And all contracts are governed by what? Laws. If you're not under that contract, how the hell can laws apply? They can't. That's like you not being under a lease, but the landlord's going to come and say, well, I'm serving you with this eviction. I'm not under contract with you. You can't evict me. I don't live there. Them laws don't apply. Come on. The fee is the price of regulation or control of the licensee, is the real aim of the legislation, which I said that in another video. A license is to control you. And it says it right there. Or control of the licensee is the real aim of the legislation. Are these licenses really used to fund legitimate government, or are they nothing more than a subtle introduction of police power into every facet of our lives? Have our enforcement agencies been diverted from crime prevention, perhaps through no fault of their own, instead now busying themselves as they check our papers to see that all are properly endorsed by the state? How much longer will it be before we are forced to get a license for our lawnmowers, or before our wives will need a license just to run her blender or her mixer? They all have motors on them, and the state can always use the revenue. Imagine that. Police power. All right, you guys ready for this? Because here's the law for the police power. The confusion of the police power with the power of taxation usually arises in cases where the police power has affixed a penalty to a certain act, meaning they put a price tag on a traffic ticket, or where it requires licenses to be obtained and a certain sum be paid for certain occupations. The power used in the instant case cannot, however, be the power of taxation, since an attempt to levy a tax upon a right would be open to constitutional objection. See the taxing power, infra. Each law relating to the use of police power must ask three questions. Is there threatened danger? Does a regulation involve a constitutional right? Is this regulation reasonable? People versus Smith, 108, American State Rep, 715, Boyle's Law Dictionary, 1914, under the police power. When applying these three questions to the statute in question, the statute in question, by the way, guys, is a requirement of a driver's license, okay? I don't know what your states would say, but like my state says, in order to operate a motor vehicle on the roads, one must have a valid driver's license. To that extent, that's what they're referring to, okay? In case you're wondering what the statute is, they're talking about driver's license requirement statute. First, is there a threatened danger in the individual using his automobile on the public highways in the ordinary course of life and business? The answer is no. There's nothing inherently dangerous in the use of an automobile when it is carefully managed. Their guidance, speed, and noise are subject to a quick and easy control under a competent and considerate manager. It is as harmless on the road as a horse and a buggy. It is the manner of managing the automobile, and that alone, which threatens the safety of the public. The ability to stop quickly and to respond quickly to guidance would seem like the automobile one of the least dangerous conveyances. Yale Law Journal, December 1905. The automobile is not inherently dangerous. Cohens versus Metal, Blair versus Broadmoor. That's 89 Southeast and 93 Southeast. And you know, that is right, because here's the thing. An automobile is no more dangerous than human error. There's that. To deprive all persons of the right to use the road in the ordinary course of life and business because one might be in the future become dangerous would be a deprivation not only of the right to travel but also as the right to due process. And if you remember, I was telling you about due process for the traffic ticket. That's what they're referring to. Traffic ticket's not lawful. It does not meet the due process requirements, and it can't. Next, does the regulation involve a constitutional right? This question has already been addressed and answered in this brief and need not be reinforced other than to remind this court that this citizen does have the right to travel upon the public highway by automobile in the ordinary course of life and business. It can therefore be concluded that this regulation does involve a constitutional right. The third question is the most important in this case. Is the regulation reasonable? The answer is no. It will be shown later in regulation infra that this licensing statute is oppressive and could be effectively administered by less oppressive means, meaning all the charges that come along with it if you violate it. That's what they're talking about. Although the 14th Amendment does not interfere with the proper exercise of the police power in accordance with the general principle that the power must be exercised so as not to invade unreasonably the rights guaranteed by the United States Constitution, it is established beyond question that every state power, including the police power, is limited by the 14th Amendment and others, and by the inhibitions there imposed. See, I was telling you guys, that's what the 14th Amendment is about. It's to limit the powers of the government and the police power, not to give them powers. You have to know that. You need to know that. The 14th Amendment was designed to limit their powers. Now, granted, they abuse their powers, but that's why you file the lawsuits under deprivation of color of law. Moreover, the ultimate test of the propriety of police power regulations must be found in the 14th Amendment. Since it operates to limit the field of the police power to the extent of preventing the enforcement of statutes and denial of rights that the amendment protects, see Parks versus State 64 Northeast 682. With regard particularly to the U.S. Constitution, it is elementary that a right secured or protected by that document cannot be overthrown or impaired by any state police authority. Conley versus Union Sewer Pipe Company, 184 U.S. LaFerriere versus Grand Trunk Railroad Company, 24A 848. O'Neill versus Providence Amusement Company, 108A 887. The police power of the state must be exercised in subordination to the provisions of the United States Constitution. Buchanan versus Wanley, 245 U.S. Panhandle Eastern Pipeline Company versus State Highway Commission, 294 U.S. It is well settled that the constitutional rights protected from invasion by the police power include rights safeguarded both by express and implied prohibitions in the Constitution. Tichy versus Osborne, 131A. And I'm going to let you guys know, in the event that you're wondering, the A does not stand for Alabama. They stand for American jurisprudence. Actually, you know what? I take that back. The A stands for, I don't know. I'm going to leave it like that. I'm not really sure. It doesn't mean Alabama, that's for sure, and I don't believe it's Arizona. I do believe it is American jurisprudence. As a rule, fundamental limitations of regulations under the police power are found in this. Oh yeah, that is right. They are American jurisprudence case laws. That's right, because I read some of these case laws in my American jurisprudence book. So, as a rule, fundamental limitations of regulations under the police power are found in the spirit of the constitutions, not in the letter, although they are just as efficient as if expressed in the clearest language. Milos versus Milwaukee, 146 Northwest. As it applies in the instant case, the language of the Fifth Amendment is clear. No person shall be deprived of life, liberty, or property without due process of law. As has been shown, the courts at all levels have firmly established an absolute right to travel. In the instant case, the state, by applying commercial statutes to all entities, natural and artificial persons alike, has deprived this free and natural person of the right of liberty without cause and without due process of law. Due process. The essential elements of due process of the law are notice and the opportunity to defend. Simon versus Kraft. Not yet one individual has been given notice of the loss of his or her right, let alone before signing the license contract, nor was the citizen given an opportunity to defend against the loss of his or her right. By automobile right to travel, by automobile on the highways in the ordinary course of life and business, this amounts to an arbitrary deprivation of liberty. There should be no arbitrary deprivation of life or liberty. Barbour versus Conley, 113 U.S. Yik Wu versus Hopkins, 118 U.S. Okay. The right to travel is part of the liberty of which a citizen cannot be deprived without due process of law under the Fifth Amendment. This right was emergent as early as the Magna Carta, Kent versus Dulles. Focal point of the question of police power and due process must balance upon the point of making the public highways a safe place for the public to travel. If a man travels in a manner that creates actual damage, an action would lie civilly for recovery of damages. The state could then also proceed against the individual to deprive him of his right to use the public highways for cause. This process would fulfill the due process requirements of the Fifth Amendment, while at the same time ensuring that the rights guaranteed by the U.S. Constitution and the state constitutions would be protected. But unless or until harm or damage, a crime is committed, there is no cause for interference in the private affairs of actions of a citizen. One of the most famous and perhaps the most quoted definitions of due process of law is that of Daniel Webster in his Dartmouth College case 4 Wheat 518, in which he declared that by due process is meant a law which hears before it condemns, which proceeds upon inquiry and renders judgment only after trial. See also State versus Strasburg 118p, Dennis versus Moses 52p. Somewhat similar is the statement that is a rule as old as the law, that no one shall be personally bound, restricted until he has had his day in court, by which is meant until he has been duly cited to appear and has been afforded an opportunity to be heard. Judgment without such citation and opportunity lacks all the attributes of a judicial determination. It is judicial usurpation, and it is oppressive and can never be upheld where it is fairly administered. 12 American Jurisprudence, First Constitutional Law, Section 573, page 269, and what they just told you right there. What they just told you right there, ladies and gentlemen, is what I've been telling you the whole time. Traffic tickets do not meet the requirements of due process. They never can, they never will. Now, I read today that traffic tickets can serve as a summons and a notice. No, they can't, because a summons has to be attached to a verified complaint. And you can't have a sworn to verified complaint in a traffic ticket unless there is a victim. So there's that. This sounds like the process used to deprive one of the privilege of operating a motor vehicle for hire. It should be kept in mind, however, that we are discussing the arbitrary deprivation of the right to use the road that all citizens have in common. The futility of the state's position can be most easily observed in the 1959 Washington Attorney General's opinion on a similar issue. The distinction between the right of the citizen to use the public highways for private rather than commercial purposes is recognized, and under its power to regulate private uses of our highways, our legislator has required that motor vehicle operators be licensed. IC 49307. Undoubtedly, the primary purpose of this requirement is to ensure, as far as possible, that all motor vehicle operators will be competent and qualified, therefore reducing the potential hazard or risk of harm to which other users of the highways might otherwise be subject. But once having compiled with the regulatory provision by obtaining the required license, a motorist enjoys the privilege of traveling freely upon the highway. Washington AGO 5960, number 88, page 11. And what he just told you there was the rules found in the FMCSA handbook. When he's saying that you were required to take a license to prove your competence of operating that automobile, he's talking about that every 2 years you have to take a physical. See, when you have a CDL, you have to take a physical every 2 years by a certified medical specialist. You're going to take a physical every 2 years to ensure that you are capable of operating that piece of equipment. Okay? Yes, I know this to be a fact. I drove for 18 years and I still have my medical card, and I still have an old CDL, which I should have bought out for this purpose. But when you go to renew your driver's license, you're not seen by a medical specialist. When you go to take your driver's test, you're not seen by a medical specialist. I've never seen a medical specialist sitting at a DMV. Okay? So public safety, smoke screen. Only through the federal, through FMCSA has the public safety actually been in regard to what is being said by law. Okay, so let's see. And that was the Washington AGO 5960, number 88, page 11. And that's interesting that it would cite that case, because I did a video on that very same Attorney General and the case, and everybody was, well, a lot of the haters was saying that it doesn't say that. Well, that's funny, because that's written straight on that page, on page 11. That came straight out of the page, because I looked it up to make sure that it was referencing that page. And guess what? Exactly what I read to you is exactly what's written in that. And unfortunately for the haters, traitors, and trolls, they don't understand that an Attorney General's opinion is very powerful. This alarming opinion appears to be saying that every person using an automobile as a matter of right must give up the right and convert the right into a privilege. This is accomplished under the guise of regulation. The statement is indicative of the insensitivity, even the ignorance of the government to the limits placed upon governments by and through the several constitutions. See, so now you know where your haters and traitors and trolls get their ignorance from the very people they vote into office. This legal theory may have been able to stand in 1959. However, as of 1966 in the United States Supreme Court decision in Miranda, even this weak defense of the state's actions must fall. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda versus Arizona, 384 U.S. Boy, this is actually pretty long. I didn't realize that this thing was that damn long for a brief of dismissal. So, you know what I'm going to do, guys? I'm going to go ahead and cut this video short, because I'm not getting ready to get into all. Yeah, we ain't getting ready to read all that. So, but we will say this right here. As previously demonstrated, the citizen has the right to travel and to transport his property upon the public highways in the ordinary course of life and business. However, if one exercises this right to travel without first giving up the right and converting that right into a privilege, the citizen is by statute guilty of a crime. This amounts to converting the exercise of a constitutional right into a crime. Now, did you hear that? If you voluntarily give up that right, okay, you turned your right into a crime. Okay? If you do not give up that right, they turn your right into a crime. Do you understand that? It works both ways. Recall the Miller versus U.S. and Sneerner versus Cullen quotes from page 5, and the state cannot diminish the rights of the people, Hurtado versus California, 110 U.S. And where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them, Miranda Supra. So I'm going to skip through that because they're all talking about the exact same thing. And what they do is they just, right here, is they recap verbatimly all the definitions: drive, crime, rights into crimes, etc., etc. Okay? So basically, in the conclusion, it says, it is the duty of the court to recognize the substance of things and not the mere form. The courts are not bound by mere form, nor are they to be misled by mere pretenses. They are at liberty indeed. They are under a solemn duty to look at the substance of things. Whenever they enter upon the inquiry whether the legislator has transcended the limits of its authority, if therefore a statute purported to have been enacted to protect the public safety has no real or substantial relation to those objects, or is a palpable invasion of rights secured by the fundamental law, it is the duty of the courts to so adjudge and thereby give effect to the Constitution. Mulger versus Kansas, 123 U.S. 623, 66-1. It is the duty of the courts to be watchful for constitutional rights of the citizen and against any stealthy encroachments thereon. Boyd versus United States, 116 U.S. 616. The courts are duty-bound to recognize and stop the stealthy encroachments which have been made upon the citizen's right to travel and to use the roads to transport his property in the ordinary course of life and business. Hadfield Supra. Okay? Further, the court must recognize that the right to travel is part of the liberty which a citizen cannot be deprived without specific cause and without the due process of law guaranteed in the Fifth Amendment. Kent Supra. The history of this invasion of the citizen's right to use the public highway shows clearly that the legislature simply, and for some reason, it did not. I could have swore I had the whole document. But anyway, so you get the gist of it, okay? This is your knowledge. All right, this was done for knowledge, guys, so that you know. You can take and keep this video. I would save it because it shows a lot of American jurisprudence laws in reference to your right to travel, and it shows you exactly how to execute it in a court of law. Same as a lot of the other things that I've been showing you how to go about it. And you got to keep in mind, there's a lot of ways that you can go about executing your right to travel in a court of law. There's so many different ways, and they're all bound by law, you know. So you get to pick and choose which one best suits your situation. So with that being said, I'm not going to let this one get as long as the other one, as I did cut out a lot of the middle part in here because this was just a little bit too much reading, and I'm quite sure that I was boring you guys, and I don't want that to happen. So, you know, because I want you guys to catch this information, absorb this information, and learn it, because that's basically what it is about. Don't just get it and keep it and put it away. Learn it, study it every day, you know, because, you know, your haters, traitors, and trolls, they know how to read case law for face value, but they don't understand the inner workings of a court, because 90% of them has never even been in a courtroom. They've never stood in front of a judge and fought a case on their own. Okay? Now, you have one of the trolls, He claims he's a lawyer, but yet he doesn't understand or grasp the concept of the supremacy clause. He doesn't understand and grasp the concept of due process. It just told you in here that a driver's license violates the due process. And I've been telling you guys for the longest, traffic tickets violate the due process. So, and I told you guys in a think video, I told you, point blank and simple, if a traffic ticket is unlawful in an administrative court and its proceedings and it violates due process, that means the action that it's governing has to be unlawful as well. Food for thought. Dark Angel. Deuces.